Just got served with a debt collection lawsuit? Well, in this video, I'm going to show you the most critical thing you need to do immediately to protect yourself. The biggest mistakes people make that cost them everything, and exactly how to respond to give yourself the best chance of winning. Hi, I'm Mike Ziegler. For more than 13 years, my law firm has helped consumers in serious trouble with debt by defending collection lawsuits and assisting with Chapter 7 and Chapter 13 bankruptcy. I've defended hundreds of debt collection lawsuits here in Florida, and I can tell you what you need to do in the first few days after getting served that can make or break your case. The absolute first thing you need to do the moment you get served is to find your response deadline. This is literally the most important thing you'll do, and missing it can cost you everything. Here's an example. Let's say someone gets served on a Tuesday but doesn't look at the paperwork until the following Monday. They see a court filing date from 3 weeks ago and panic, thinking that their time is up. But the clock doesn't start ticking until the day they were actually served, not when it was filed with the court. Here's how to find your deadline. Look at the document called the summons. It will be attached to the lawsuit paperwork, typically towards the front. The summons will tell you exactly how many days you have to respond. In Florida, in a county court or circuit court case, you typically have 20 days from the date you were served to file a written response with the court. Don't get confused by other dates on the paperwork. There might be a filing date stamped by the court that's weeks or months old. Ignore that. Your deadline starts from the day that the process server handed you the papers or left them at your door. Put this deadline in your phone immediately. Set multiple reminders. I recommend setting an alert for 5 days before the deadline so you have time to prepare your response properly. Missing this deadline is the biggest mistake you can make. Now let me tell you what happens if you ignore this lawsuit, because the consequences can be severe. Over 95% of debt collection lawsuits go unanswered. This means 95% of people just ignore the paperwork and hope it goes away. This is exactly what the debt collectors are counting on. When you don't respond, the court enters what's called a default judgment against you. This means the debt collector automatically wins and gets everything they asked for in the lawsuit, often the full debt amount plus attorney's fees, court costs, and interest. Once they have a judgment, they can garnish your wages, freeze your bank account, and place liens on your property. In Florida, they can take up to 25% of your gross income through wage garnishment. They can also freeze your bank account and take whatever money is in there. A judgment's valid as a lien for up to 20 years in Florida. The debt collector becomes a judgment creditor with powerful collection tools they didn't have before. This is why ignoring the lawsuit is the worst thing you can do. The good news is that you have options. You can either fight the lawsuit or try to settle it. Both are valid strategies depending on your situation. Fighting the lawsuit means filing an answer that denies their claims and raises defenses. Common defenses include the statute of limitations has expired, they can't prove they own the debt, the amount is wrong, or you never received the proper notice of the debt. Many collection lawsuits are filed by junk debt buyers who purchase the old debts for pennies on the dollar. They have incomplete records and struggle to prove their case in court. If you make them prove their case, many of these lawsuits fall apart. Settlement is also an option. You can contact the debt collector's attorney to discuss resolving the case. Settlement discussions are confidential and can't be used against you in court if negotiations fail. You might be able to settle for significantly less than the full amount claimed. The key is having leverage. If you file an answer and make them work to prove their case, you're in a much stronger position to negotiate a favorable settlement. Now let me show you exactly how to respond properly to protect your rights. You need to file a written answer with the court within your deadline. Your answer should respond to each allegation in the complaint. Depending on the allegations, you might respond by stating denied or defendant lacks sufficient knowledge to admit or deny the allegation. But if the allegation is valid, often admitting would be accurate. You should raise any defenses you have. Common defenses include statute of limitations, lack of standing, failure to state a claim, and demanding that they prove the debt with proper documentation. After filing your answer with the court, you must serve a copy on the debt collector's attorney. This is usually done by mailing a copy to their office. Make sure that you filed a certificate of soft service with the court showing that you provided them with a copy. Your answer doesn't have to be perfect, but it must be filed on time. The main goal is to avoid a default judgment, force them to prove their case. If the debt is legitimate and you can afford to pay, settlement might make sense. If you think the debt is wrong, too old, or the collector can't prove their case, fighting might be the better option. Either way, you need to respond within your deadline. Don't let them win by default when you have good defenses or settlement options available. If you're in Florida and facing a debt collection lawsuit, don't try to handle this alone. Give us a call at 727-538-4188 for a free consultation. We'll review your case, explain your options, and help you develop the best strategy for your situation. And if you want to learn more on how to eliminate your debt problems, then watch this next video.